I got a B, and I was like, not happy. So then second semester, I took the midterm, got a C, again, wasn't happy. So then
There's a good ending, though.
Yeah, I mean, like that, I got a C, guys. No, then for the final, I got an A. So you can do it, too. But I know you guys aren't doing your midterm this year, so I really encourage that because Blackman's exams are very unique, and they're just like not a lot of other professors test. Anyways, they're great. So we'll like go over that in Langdale because there's word limits, and I struggle with word limits. So you too struggle, I can help you. But yeah, just email me, or you can text me. I respond more to text, but I didn't put my number up here, so never mind. Email me. So can't wait to see you guys on Saturday.
Thank you, Kendra.
Thank you.
Thank you so much. In particular, I had asked Kendra, she has to go to class, that's why she's running out.
Oh, no. I'll go to the later one.
Okay. In particular, I had asked for the first session to help you with your notes and your outlines. This is something that you need to get a handle on at the outset. Later classes, I asked her to go over the midterms from last year, which I think I encourage you to do. So please go. It will be very helpful for you. And if something doesn't make sense, you come talk to me. I'd be happy to clear up anything. Okay? Thank you. Okay. Any questions or things on your mind from last class about deeds, about delivery? Anything?
Can we come back to you in a minute if we think of something? No?
I'll probably forget to ask. One note, there's no class on Tuesday. I will not be here on Tuesday. On Wednesday is Constitution Day. Please celebrate September 17th, the day the Constitution was signed. I will be celebrating it, not here. But I always celebrate it in DC every year, Constitution Day. Okay, let's start with the poll question. Okay, start poll. All right, to bridge us from last class, this one should be easy. Who is the mortgager? The buyer or the lender? Okay, very good. All right, let's see what we got here. Okay, I mean, not 100%, but close to it. 85%, which is good. The answer here is A. The mortgagor is the buyer. And why is that the case? The buyer is the one who actually gives the mortgage to the bank. It's the opposite of what you might think intuitively. The buyer gives the bank the mortgage, and in response, the bank gives the buyer what's called the note, or the promissory note, which means the money. And until that money is paid off, that note is held. Okay, and once the money's paid off, the mortgage is released. Okay? Yes, sir. You remember your question?
No, but the opposite is mortgagee, right?
Yes. The buyer is the mortgagor. If I spell that right. And the lender, the bank, is the mortgagee. Okay, any questions on that? Okay. Our topic today is on what's called recording. And this is a topic you've probably encountered before, but we never actually discussed. You've seen questions where it always says the deed is recorded or the deed is not recorded. What does that actually mean? Recording is a system that was developed to provide notice, right? The most important thing to remember about recording is it's designed to give people notice. Notice of what? The history of a property. Who owns it today? Who owned it 5 years ago? Who owned it 10 years ago? Recording also gives notice about any clouds on the title? Is there a mortgage pending? Is there maybe a lawsuit pending about this property? Does someone have a remainder on it, right? Is there some future interest floating around? The idea of recording is to always put together a chronology, a summary of all the things you would need to know about a piece of property. These are all public records, right? Any of you could go to the Harris County Courthouse and search for the history of your home or the history of your neighbor. Yeah?
How would you consider this different from like the insurance that you said you had bought on like a house that says that there's no...
That's related. We'll get there. Okay? Anyone can go search. Now, it's not easy, right? It's going to take you a lot of time, which is why when I bought my house, I didn't do it myself. I think I would do a bad job. I paid someone to do it for me, right? You pay to have a title survey performed. And that's a function performed by, Jacqueline mentioned, the title insurance company. They have people who are trained to dig through these records and to provide you a survey, or a summary, if you will, of the history of that property and whether there are any possible clouds floating around the title. Okay. Now, I want to make this point very clear at the outset because this often confuses students. If I sell my home, right, to Jacqueline, and we don't record the deed, the transaction's valid, right? Between Jacqueline and I, or Jacqueline and me, I should say, there's no requirement to record. I sold her Blackacre, she got it. Whether or not either of us records are irrelevant. As between the two of us, between the grantor and the grantee, the transaction's valid. You don't have to record it. Now, the problem arises when Jacqueline sells it to Zeke. If we fail to record our deed, Zeke doesn't have full knowledge of the history of the property. Okay, let me put this very bluntly. Recording problems only occur when there's a third party. When it's between the grantor and the grantee, recording is irrelevant, right? It's binding between the two of us. But when there's some third party or a fourth party or a fifth party in the picture, then recording becomes significant. Okay, everyone get that point, right? So you're going to get confused on this point later, I promise you will. But the general point is between two people, the recording's irrelevant. But once there's a third party in there, the relationship between Zeke and Jacqueline, or between Zeke and me, the recording then makes a significant difference. Okay, everyone with me? Okay. All right. I'm gonna. All right. Who's next? Oh, Brianna. Thank you. Okay, Brianna. What are the two kinds of indexes that exist in the United States? Okay, very good. So first, tell me about the tract index, which is one students are very attracted to, but they're not very common.
The tract index is like the less frequently used one in the
Yeah.
United States, and it assigns a number to all of the pieces of property, and that's how they're indexed, and that's how you can
Yeah.
identify them.
Yeah, very good. So remember the game Battleship when you were a kid, right? You know, it's a grid with numbers and letters along the top. You know, like B. You ever play bingo, right? B5, right? Imagine defining the city of Houston to a grid with letters along one way and numbers along the other. You could find any spot by matching up the numbers in the grid, right? That sounds awesome, right? Why would we not use that? Because most property systems did not develop in a single day. They developed over the years. And properties were not laid out on a specific grid. They developed incrementally. So there are very few jurisdictions that actually have a tract index where, like, 1303 San Jacinto Street is lot number 52, whatever the number it is, right? We don't have that. Instead, most jurisdictions, Houston included, uses what's called the grantor-grantee index. Gabriella, tell me, please, what's a grantor-grantee index? How does this work?
There's like the grantor index, so whoever transfers the land that is under that person.
Uh-huh.
The grantee index,
Okay, good. So let's keep our terminology straight, right? The grantor is the person selling the property, conveying the property. The grantee is the person receiving the property. Okay? All right, so Jalen, let me ask you a question, please. I want to sell you Blackacre, right? You know my name. My name is Josh, right? You want to know, does Josh actually own the property? Where would you start your search if you're buying Blackacre for me and you know my name is Josh? Where would you start?
I would have to start with your name and like go individually. All
Right.
the way back.
Which index do you use, though? Grantor or grantee?
I believe the grantee.
Oh.
Grantor.
Ooh, don't help her. Which one is it? Which one is it? I hear two answers. Yeah, 50-50. You're buying it for me, Josh, right? I'm the seller. You know my name. Where do you start your question? Where do you start your search?
So you do start with the grantor. You look.
Now,
You keep going.
what are you trying to see, Jalen? What do you want to know about how I got the property? What are you trying to find out?
Trying to see who gave it to you.
Aha. So where would my name be listed if you want to see who gave it to me?
So you would be under the grantee.
Bingo. Hear what she said? She got it. Okay. Everyone wants to say grantor because I'm the grantor, right? I'm selling it, right? It's just intuitive. Like, of course, the grantor, but that's not right. You're not interested in me as the grantor. What you want to see is me as the grantee. Where did I get it from, right? Where did I get Blackacre from? Who sold it to me? And that's how you up the chain. So your search will always start with the grantee index. And you're starting your search with the guy selling it to you, right? That's the only person you know. You don't know where I got it from. Maybe I'll tell you a person's name. I'm lying. I'm making it up. You can't trust that. The only thing you can trust is you know what my name is. And that's where you start your search in the grantee index. Okay? Please don't mess this up in the exam. Half of you will, but you start your search in the grantee index. All right, so go to 664, please, towards the bottom of the page, or I guess middle of the page. There it is, yeah, halfway down. It says, assume that a man, okay? All right, I want to walk through this example, this paragraph, painfully slowly. Painfully slowly. It's going to take a while, but I think if I walk through this slowly enough, hopefully you all grasp this material. I make no assurances, but if you walk through with me one step at a time, you'll be okay. Okay, so it begins. It says, assume that a man named Dubeck, and by the way, the names in this case are Cotter, Dubeck, Anderson, Barker. Why? A, B, C, D. They're in alphabetical order. I will almost always in the exam give you A, B, C, D because it's just one less thing to worry about. I don't guarantee it, but I usually do. And one other point, you have O, Oliver at the end. Why O? Original. So if you see a guy named O, Oliver, Oscar, whatever, that's probably the original grantor. This is like property cheat sheet stuff, but it will help you immensely. So A, B, C, D. It just makes it really easy for you to figure out. Okay. So it says, assume that Dubeck is selling you Blackacre. You want to find out how Dubeck got it. So as a result, Jalen told us a minute ago, you start in the grantee index under Dubeck's name. Right? And what does that actually mean? We're now in the year 2019. You don't know when Dubeck acquired Blackacre. You have no idea. And again, even if he tells you when he got it, he's probably lying. Right? Just in this class, assume everyone's a crook. You just have to assume it. All you know is that there's a guy named Dubeck, and he claims that he presently owns Blackacre. That's all you know for now. Okay, so you start and you say, okay, I'm going to take out the 2019 index and look for any reference to Dubeck. Rachel, can you search for Blackacre? Wouldn't that make it easier? Yeah, we don't have a tract index. You can't search by property name. Wouldn't it be awesome to say, oh yeah, let me see the history of Blackacre every year? No, you can't do that. That would be too easy, right? You can't just like Google who owns Blackacre in 1995, right? That's not what we have, unfortunately. Now, some jurisdictions are computerizing it, but you still have to go the old-fashioned way for older records. So you still need to do this. Okay, so you look in 2019 for anything with Dubeck. You look in 2018 for anything with Dubeck. 2017, 2016. We're talking thousands of pages, right? This is not an easy search. There's a lot of things you have to look at. And then eventually, you keep going backwards to 1977. My God, that's 40 years ago, right? 1977. And you see a deed from Dubeck to Cotter. I'm sorry, from I said a deed from Cotter to Dubeck, right? So Cotter was the grantor, and Dubeck was the grantee. Okay, so you know at some point in 1977, Cotter sold the property to Dubeck. Yeah.
I know this problem doesn't provide it, but typically when we're looking at this type of index, there would be particular dates. And that
Yeah, yes, January 25th, whatever happens to be. This makes it a little easier. Okay, so Tommy, let me ask you a question, please. We know that there's a record that Cotter sold it to Dubeck in 1977. Does that mean that Cotter owned Blackacre in 1977? But do we know for sure that Cotter is actually the owner? Why? What could possibly have happened? Could have engaged in fraud. He could be engaging in fraud, right? Just because Cotter sold to Dubeck in 77 does not mean that Cotter actually owned it, right? And indeed, Cotter sold to Dubeck in 77. Tell me, could Cotter have sold to someone else the year after? Yeah. So maybe in 78 he sold it to someone else. We don't even know that person's name. Maybe he sold it to someone else in 76. So tell me, what do you do then to try and figure out Cotter's deal? What do you start searching for? Exactly, in the grantee index, right? You want to see at what point did Cotter acquire Blackacre? Or maybe he didn't, I don't know. And to do that, you use the grantee index. Why? Tell me why you use a grantee, not grantor? What are you trying to see? Why are you searching for Cotter in the grantee index? What are you trying to figure out? But specifically, what's the grantee? The receiver. Exactly. You want to see when did Cotter receive it. Because maybe he just bought it normal. But what happens if there's no record? Like Melissa, for example. What happens if there's no record that Cotter ever actually received the property? What will that tell you? Melissa?
If there's no record
that his name shows up nowhere. He conveyed it to Dubeck for sure, but there's no record that Cotter ever actually acquired Blackacre himself. What does that tell us?
to tell you that he did buy it, but it wasn't reported.
Okay, so one possibility is he bought it but never recorded. There's another possibility. He's a crook. Yeah, I always assume people are crooks. Maybe I'm too jaded from teaching his class for so long. But maybe he bought it and never recorded it. But maybe he's a crook. Maybe he just pretended. Maybe acquired through adverse possession, right? There are different ways he may have come into ownership. Yeah?
So you said the recording problems only shows up when it's a third party involved. But isn't it always like a third party? Like,
Yes, of course.
Okay.
Yeah, there are always a third party in any question I'm going to ask you. But if I ask you between the two of them, is it transaction valid? The answer is yes. Yeah, okay. But I want to go back to Melissa's statement a minute ago. It's possible that Cotter never recorded, or maybe Cotter's a crook. Maybe he got through adverse possession, right? There are a lot of ways he may have come into hands of Blackacre without having the paperwork. Well, that's what Mr. Robinson did, if you remember, right? He recorded his declaration of adverse possession, saying, I am squatting. The reason why he did that was to start the clock. That was the first day of class, right? He had that little document he recorded with the county.
But if he had the sufficient amount of time,
You don't need to. You don't need to do the paperwork, but he did it to establish when his clock started. Because that date was when his clock started for the 5 years. Or 10 years, whatever it was. Okay, everyone with me? All right, so we know that Cotter gave it to Dubeck in 77. Okay, so now we look in the grantee index under Cotter's name, and we go 77, 76, 75, 74, 73, all the way back to 1952. And we find a deed from Barker, B, to Cotter. So in 1952, some 25 years earlier, Barker sold to Cotter. Now, we don't know exactly what happened in those intervening 25 years, but at a minimum, we got a new name, Barker. Okay? So now what do we do next, Ben? We know who Barker is. What's our next step?
You can switch to the grantee index, or you keep going back until you
Which index do you search?
the grantee index,
Why grantee?
because you want to go back to the original.
You want to figure out how Barker got it when we see the grantee. Again, we do not switch indexes until we get to the end. We'll get there in a minute, right? But we have to switch. We have to stay in the grantee index. Okay. Okay, so now you look in grantee index for Barker. When did he get it? 52, 51, 50, 51, 49, et cetera, right? We eventually run back to the year 1900. Now, in reality, we don't stop at 1900. We go even further, probably. But this question just stops at 1900 to make it easier. Eventually, we find that, let's just say Barker, or Anderson, I'm sorry, got it from Oliver in 1900. So Oliver is the original owner. Oh, okay. Make it really simple. Trevor, what happens once we figure out who the original owner is? What do we do at that point? We switch. Why do we switch? Yeah, so here's how it works, guys. You start with the grantee index of the present year. You go all the way back in time to the original grantor. Then you switch to the grantor index, and you go all the way up to the present day, right? You always start with the present, the grantee index, go down. When you get to the original grantor, you switch. You go back up to the present. So it's almost like you're cycling through the same years twice, but we'll find they're not always, they always match up. Yeah, Jennifer.
How do you know it's the original grantee?
It's a myth, right? And we'll do the thing from Louisiana in a minute.
Right.
There is no original grantor. At least in Texas, let's say if you have an oil and gas reserve, they'll go back to basically the times of the French, right? They'll go back hundreds of years, right? They go back to the Louisiana Purchase maybe. You go back as far as you can. 100 years is probably not enough in most jurisdictions, but this makes it easier for you. Yeah, I like that, the Louisiana, who owns Louisiana thing, right? It's kind of cute, but it illustrates the point. God owns Louisiana. I had a flight attendant yesterday. I was in the exit row and he was in his briefing. He's like, "Are you able to assist?" Yes. Verbal acknowledgement. Yes. Then he's like, "Who's the greatest football team in the United States?" He's like, "LSU." I'm like, "No comment." Alvin's question: is LSU the best football team? I'm like, I don't know. Yeah. I was actually in Austin last week when the Tigers went to Austin. Basically, everyone on my plane was actually like from Louisiana. They're all flying to Austin for the game. Anyway. Okay. All right, so we go back to Oliver, and we start with the grantor index. And we look for Oliver in the grantor index in 1900, 1901, 1902, 1903, and eventually we go to 1915. And we find that Oliver gave Blackacre to Anderson, A, right, in 1915. Okay, who am I? Is that Kyle? So what happens once we find Anderson's name in 1915? What do we do next?
Then on the grantor side, you start going back down, working your way up to 2019.
Okay, but what name do we start looking for once we hit 2015? I'm sorry, 1915.
Anderson.
Okay, that's right. Once we stop looking for Oliver. Okay? Right? Once you hit Anderson's name, you start looking for. Once you hit Anderson's name, start looking for Anderson. Okay. Then we get forward. We go forward, and we find. Here comes a wrinkle, right? We find that in 1934, Anderson sold Blackacre to Barker. In 1934, but this is common. The deed was not recorded for 5 years. The deed was not recorded till 39. Okay? Now, why is this a problem, Matt? Why is this problematic if the transaction occurred in 35? I'm sorry, 34, and it wasn't recorded till 39. Why is this problematic?
For 5 years, the
That's right. So what happens, Matt, if I went to the records office in 1935, who would be the owner of Blackacre at that point? If I just look.
Anderson.
How would you know it's Anderson?
He would be the record owner.
That's not what I asked. I said if you went to the courthouse in 1935 and you tried to figure out who owned Blackacre, who would show up as the owner of Blackacre?
Anderson, right?
What evidence is there that Anderson owns Blackacre in 1935?
I'm confused. Anderson transferred it to Baker, correct?
Right. So my point is, what evidence do you have? What's actually in the records office? There's no evidence. Right, so then we have a difficulty, right? So the next sentence says, then you drop Anderson's name at 39, but you start running Barker in 34, right? And why do you do 34? Because that's when the transaction occurred. In 34, Matt, I didn't mean to give you difficulty, but actually the actual owner was Barker. Of that, right? So you start searching for Barker's name in 34. To see if anyone else may have tried to acquire it. Okay? But you can keep searching Anderson's name till 39. Why? Because until 39, Anderson was still the owner of record. Morgan?
But when, if this problem did happen, wouldn't adverse possession allow the person to still have title to this, like someone else? If Anderson did give it to someone else, and they never like.
I don't know if 5 years would be enough in this case. Maybe.
Well, if this was like due back next year, though, would this would be
Uh,
a problem for him?
You can always claim adverse possession if you meet the elements. That's not always easy to do. Yeah, but you could. Good thought. Yes, Jacqueline?
I don't understand how they could have done this. Like, would they have
I'm
just
good.
had to provide, like, a sales contract to the record, and that would have made it, like, valid?
Look, the deed is dated. It was signed and dated 1934, and they were lazy and never brought it to record till 39. That's fine. There's no like time frame by which you have to record something, but the failure to record it in a prompt fashion means you might lose the protection of the statute, of the recording statute. Right? You don't have to look. You never have to actually record anything. There's no requirement between A and B. This was a valid transaction. That's my point before. It's valid. It only becomes problematic if there's C now. Okay, everyone with me? All right, so then you eventually get to 1939. You start searching for Barker. Then you find 52, the deed from Barker to Cotter, which was executed the same day. Okay, they were diligent and they recorded it right away. Very good. Then you go Cotter forward in the Grandex, 1952, Grantor Index, and you see 1977 for Dubeck. And then you see Dubeck's name from 77 to the present. So what did we do, right? We calculated the entire chain of title, right? Alyssa, what does chain of title mean? What does that phrase mean?
Like the person that is gone, the property is gone.
Very good. Refers to the history of the property, right? Who owned it at which point in time? And let me see if I could summarize this in a bit. So from 1900 to 1915, who owned it? It was Oliver. From 1915 to 1934, it was Anderson. From 34 to 52, it was Barker. And 52 to 77, right, it was Cotter. And then 77, Cotter got it, and Cotter has it till the present. I think that's right. You can only say those years with confidence if you do the entire loop. You start with the grantee index to the present, go back to the original, and loop back up to the grantor index to the present. You have to do both directions. You'll see some of my old exam questions where the columns don't match up, right? Here, everything matches up nicely. But imagine the documents are not precise. Maybe before copy machines were made, they had a typewriter, and they just manually made copies, and maybe one of them says January, the other one says November, right? Maybe just the dates are wrong, just type in the wrong date. These create issues that are very hard to resolve, so be very attentive to dates. If Jacqueline asks, I only have years here, on the exam I can have dates, maybe one is February 28th, the other one's February 29th. Maybe it was a leap year, something weird, right? And you have to deal with those. Yes, Stephen?
So if I'm correct in thinking this, most of your issues are going to come up when you come back up the grantor list?
That's when you spot errors, right? When you go down the grantee index, you don't know enough that things are off, right? So when you go down the grantee, things like, okay, that makes sense. But when you go back up, you say, okay, these don't match, right? Now there could be a gap, right? Let's say that, Cotter got in 52, and then there's like maybe a 2-year gap in the middle. You can't quite figure it out. Or maybe when you see the deed in the grantee index, there's a gap. It was executed this day but recorded that day, right? So you can find errors, but generally you figure that things aren't lining up when you go back up to the grantor. That's often when the things arise. But you have to go down and up. You have to go through the entire slog. You can't jump through it. If you do this quickly, you blow the question. Yeah, Jennifer. Are you talking about the buyer and the seller?
Yeah.
There's no requirement to record. That's not a thing you have to do. But the failure to record might get you in trouble. If you fail to record, you cannot rely on the recording statute to protect you. Right? Think of the notice statute, the race notice statute. So there's an incentive to record to get protection, but you don't have to.
So when you buy property, it's not in the contract that the buyer or the seller will record?
I don't remember a term in mind. I don't know if anyone else has any recollections. I can't recall that. We recorded it as a matter of course because you don't want someone coming along to claim they own Blackacre.
You yourself went and did that?
No, our title company did it for me. I didn't do anything myself, right? You pay someone to do it, but that's one of the things they do. I actually remember they mailed us a copy of the recorded deed at some point. Okay, one with me. Actually, Jennifer, you're next. Let's do that Louisiana one. I like that one very much, right? It's sort of the cute history of Louisiana. So what's the history there?
The history of Louisiana?
Yeah.
Okay. They wanted to go back far enough.
Well, how did the court actually trace the history of Louisiana? Or actually not the court, but the lawyer.
That there was a treaty from the U.S. The Treaty of Louisiana from France. Then France had gotten it from the Spanish crown.
Yeah.
Conquest, the Spanish crown acquired it by virtue to Christopher Columbus.
Yeah, right.
Christopher Columbus was authorized by the King of Spain.
Who authorized her?
The Pope.
Not God yet. The Pope. Okay. And who did the Pope get his power from?
Jesus.
Yes. Yeah. Where'd Jesus get his power from?
God.
So who made Louisiana?
God.
Yeah, God made Louisiana. Right. I like that one. It's fun. Of course, there's something missing in the chain, which is the natives. There were people here before we got here. But it illustrates that at any point in time, someone has to own property, right? Property cannot be ownerless. So you always have to account for who owned what. Generally, in Texas at least, you have to go back to at least the 1600s and the French and Spanish occupation. We had a student here a couple years ago. I can't remember his name, but his family actually claimed a plot of land in Texas to the Spanish crown. Like the same land had been in his family since I'm gonna say the 1700s, but it was an old Spanish territory. So I mean, they actually traced it back, which is insane. But you have to do that because if you start at 1900, you have people who have familial claims to the 1600s. You're going to lose. This also comes up a lot with oil reserves, right? Where someone has a piece of property in West Texas, was never very valuable. It's just sort of stay in the family. They discover oil, and all of a sudden, all these cousins and nieces and nephews come along, and you have to basically trace back who the original owner was, and then divide up based on all their heirs, assuming there are no wills, and it's impossible. I had one student sat right there a couple of years ago who had, some family land, and there was oil, and 50 people showed up. It's like, okay, it's mine, right? Give me a share, and this happens quite a bit. Okay. Any questions on that exercise in 664 or the Louisiana thing? If you didn't get what I just did, 1 second, Laura, go back and rewatch the first 20 minutes of this video for the class and just go paragraph by paragraph, because you need to actually do it. You can't just read it and be done with it. You have to actually understand why you start the grantee index, how you go step by step, and why you get back up. You have to get that. If you don't get it, come talk to me, but this is an important point. Yes, Laura?
On an exam, you would tell us like who the original owner is? Like we have to give back to?
Maybe.
Or we gotta go all the way back to God?
Maybe. Well, no. I don't have such divinity in my class. No, I think I'll tell you how far back you have to go. I don't think you have to go back to the Almighty. If you want to, Lord help you. I may not give you the original owner, but you'll have to do the best you can. I mean, keep in mind, it's not always clear who the original owner is. And sometimes you may have to buy a property going back only 150 years, not 300 years. And you take a risk that someone comes along, has a superior claim to you, which is why title insurance is important, right? The title insurance companies will give you a policy, say, look, we can go back 150 years, we can't go back 300 years, so we'll sell you a more expensive policy to guarantee your title, right? So you can do it, but just understanding there might be a risk. And my God, after those hundreds of years, there's probably some adverse possession that comes along. But, and here's the big but, oil, right? No one's using the subterranean rights, so it's not actually being occupied. So you don't have the same sort of like adverse possession for your subsurface rights, which is why 50 cousins come around and say, hey, cousin, good seeing you again, right? You're nodding, right? Yeah. This happens a lot, and this is why people who die without wills leave it to hundreds of heirs after a couple generations. Okay, who's next? Oh, you're next. Okay, Zeke. Oh, Tyler, go ahead.
So these indexes, sir, do they tell you the type of deed?
Yes. So let me show. I have a picture, I think, on the notes, and there's a picture in your book here. This is actually what the old record books look like. They're all electronic now, but the older records are on paper. And you'll usually it's hard to see, but it's in your book also, so you can make it bigger. This is the grantor index. This is the grantee index. This is kind of deed, the date of the deed, and description of lots. So it'll tell you what kind of deed and what kind of document you're recording.
And so if Mr. Lutz, like, he won his adverse.
Oh, first you're talking about Valkenburg, the first
Yes,
week
sir.
of class, yeah.
Yeah, he won at the trial court level,
Mhm.
and it took a couple years. What would happen index-wise, recording-wise, when somebody wins an adverse possession claim? Who maintains the responsibility to go and is there any kind of like adjustment they need to make?
Oh, well, I don't think you have a final judgment yet. I think you'd have to wait for a final judgment until you record it, because any judgment pending appeal can be reversed.
Okay.
I think that's the answer. I'm not sure, but that's what I would say. But ultimately, after the final judgment, you'd have to have an entry, a recorded entry. Okay. Zeke, let's talk about Old Mother Hubbard. Luthi v. Evans, what happened there?
Sure. 1971, Grace v. Owens owned a number of interests in the oil and gas leases in Coffee County.
Mm-hmm.
Then by a written instrument, she assigned all of the oil and gas interests to international tours.
Okay. Now, Zeke, what's the problem with this sort of Old Mother Hubbard clause, as they call it, where basically she says, I assign all of my interests within this county? Why is that problematic?
I guess how I understood it is it doesn't really specify which interests in particular. It just says all of them.
Yeah, right. Again, the primary purpose of the recording system is notice. It's designed to put people on notice of who owns what. In this case, there were several different leases that were spelled out. You get this lease, and you get that lease, and you get this lease, right? So any competent person doing a title search would be able to know what is the status of those lands. But then we get to this, what they call the Mother Hubbard clause, and you don't know why. It's a nursery rhyme. Old Mother Hubbard went to the cupboard to give the poor dog a bone. When she came there, the cupboard was bare, and so the poor dog had none, right? So the idea that everything's in the cupboard, right? Everything's together. I actually had a student a couple years ago. She said she was at a law firm, And she was the only one who knew what this was. So it came up, and she was very proud. So there you go, South Texas, right? You're welcome. These clauses are common for deathbed wills, right? Imagine a person's on their deathbed. They're very sick. They're old. They don't really know what they have, but they want to leave everything to their daughter or their son or their husband or their wife, whatever, right? So you can imagine why in a deathbed confession you'd put these sorts of Mother Hubbard clauses. But in commercial transactions, they're problematic. They're problematic because these are expensive mineral leases for oil, and someone doing a title search may not find it, right? If I want to look for this Kufel lease, Kufel, I don't know how to say it, the Kufel lease, there's no way that I can know who owns it and when. Okay? So Jacqueline, what does the court do here with the Mother Hubbard provision?
They consider state Kansas statutes
Okay.
that govern the custody and recording of instruments of conveyance.
That's right.
So you want their decision? Or
Yeah, what do they do? What do they hold?
They had said that it was for tours, not for births.
Why?
Because the initial assignment stood for like first.
Was the Mother Hubbard clause valid?
No.
Why?
Because it was unspecific.
Very good. The Kansas law required specificity, right? The Kansas law, I think law in just about every state, requires a description of what's being conveyed. The Mother Hubbard clause doesn't satisfy that. Now, here's the important part, right? As between the grantor and the grantee, the Mother Hubbard clause is valid, right? Right, Ernest, let me ask this question, right? Let's say that the Mother Hubbard clause was signed, and then the grantee recorded a deed that says, I now own the Kufel lease.
The grantee?
Yeah. And instead of just recording the Mother Hubbard clause, he records a deed saying, I own the Kufel reserve. Will that change his fact pattern at all?
That seems to be a bit of a problem because they're saying you haven't specified that.
Yeah, go with me, right? So I'm saying they signed the Mother Hubbard clause, right? And then the grantee records something saying, I own the Kufel lease.
I think that's a problem.
Why?
Because she didn't say Kufel. She said everything.
But wait a minute, Ernest. But didn't I just say between the grantor and the grantee, it's valid? So who actually, was the conveyance valid?
Yes.
Okay, so this is the wrinkle, right? This is why I made that point at the outset of class. The Mother Hubbard clause was valid to convey the property, right? This sort of just, it messes with your mind a bit, right? But we don't ask who owns something. I ask a different question. Who has a stronger claim to it, right? The purpose of recording statutes is not to say who owns it. Don't get that phrase out of your head. Don't say who owns it, right? Say who has a stronger claim to it. Who does the law give a stronger claim to? So as between the two of them, right, the grantee got it. But the third party comes along. And when the third party comes along, then the recording matters. And the fact that the deed that was recorded didn't mention the Kufel means that there was no way for the third party to know about it. Okay? So between the two of them, between the grantor and the grantee, Owens and Torres, right? That's fine. But when there's a subsequent third party, the court holds that the Mother Hubbard clause does not provide constructive notice. That the Mother Hubbard clause does not provide constructive notice to another purchaser. You need a description, some specificity. Right? Right. Therefore, the conveyance from Owen to Torres was not enough to provide constructive notice. Therefore, it was not valid. Okay? This case is basically a simple proposition that when you want to convey property, you have to be specific. It's a long way of getting there. Although, look at note number 2, it actually cites a Texas case. Texas Consolidated Oils versus Bartels from 1954. I looked the case up last night. I didn't really dig too deep into it, but there was a lease in Texas that basically said that conveyed all the rights of all property I own in Texas, New Mexico, Kansas, Oklahoma, and Louisiana, and the court upheld that as providing constructive notice. So there are some splits of authorities. I can't imagine this is a popular rule because it makes searches impossible, right? You now have to search for every conceivable property, right? Now, Stephen, let's say that Grace, right, our beloved Grace, if you know Grace's name, you could search for all of the properties that Grace owns, right?
Yes.
Look at it in the grantee index, right? What if you don't know Grace's name? What if you just want to buy Kufel and you know nothing about Grace? How on earth are you supposed to figure out Grace is in the chain? What are you supposed to do? I mean, there's something you can do. It's not pleasant, but you can do it.
You have to search item by item for that property.
You search everything. You understand what I'm saying? You search every single record in a county ever that might reference Kufel. You're not searching by name because you don't know a name. So you basically have to search everything. You have to go through every line in every index book. Eventually you'll find Kufel and Grace. And then you can figure out the Mother Hubbard clause. So the cost of doing that sort of search is significant, right? That's a lot of effort and time. But when you have this rule like the Texas case I mentioned, that's what the rule requires, to actually manually dig through hundreds of years of records. Yeah.
So, for instance, if somebody was going to sell a ranch, would the property be called like J Ranch in there?
Oh, wouldn't that be nice? Look, it might be meets and bounds. It might be the ranch between the river and the stream and the creek, right? It might be some vague description. So it's not going to be easy searching Kufel. You're going to have meets and bounds, which makes it even harder.
So you really have to have a good description of the property.
And if you don't have it, you have to guess around because it's not going to be called. It probably won't say Kufel in the book.
That might be a more recent.
Maybe change names. Maybe it was Old McDonald's farm, then Old Brown's farm. You know, things change names over the years. The only thing that stays constant is the person's name. Yeah, Abrams and Barker and Cotter and Dudek, right? You can search for names, but the names of property is a lot harder to search for. That's why title insurance is expensive. Raise your hand. Raise your hand first. Thank you. Good. Oh, that messes with you, right? Doesn't it? You would then need to find evidence the person changed his name. That actually is similar to the second case where you misspell a name. But if someone legally changes their name, they're required to actually report that. So I haven't thought of that, but technically, if you're searching for a person's name, you'd have to search for any aliases. Maiden name, for example, right? That's on you. I think there was a case, maybe they took it out of the book. There used to be a case, I think, with a maiden name where a person got married and the title search company only looked under the married name. They didn't check the maiden name. And generally, when a person changes their name, that's public records. You have to search, are there any aliases? When you all fill your bar application out in about 2 years, they'll ask, do you have any aliases? Are you going by maiden name or married name? So that, they always want to know what are all the names you're known by. And that's not even misspelling Elliot with 2 T's and 1 T and L. That's the next case. There was no spell check back then, right? Okay. All right. Any questions on the Grace, the Hubbard case? There's a few things in the note that are worth mentioning. Bobby, what happens if the clerk at the courthouse doesn't record your deed correctly? He's negligent. And because of that, you lose your land. Can you sue him? No. They're immunity, right? So they have government immunity. So if the clerk messes up and doesn't properly record your deed, too bad. can't fight City Hall, I guess. Don't worry about that stuff on the government survey. It's way too confusing. I stopped assigning that years ago. Okay. The next case, Orr versus Byers. I'm sorry, name tag?
Oh, sorry. Caroline.
Caroline. Okay, Caroline, let me ask you a question. What was the error that was made in Orr versus Byers, our next case?
The last name was spelled wrong.
Yeah. Yeah, this is one of those cases where the lawyer screwed up, right? The lawyer screwed up. Okay. A judgment was obtained against William Dwayne Elliott. What does that mean? Dwayne Elliott owes us some money. And the guy's name was spelled I'm sorry, the lawyer wrote Elliot. That's the lawyer wrote. And Caroline, what was his actual name?
Elliott.
Okay. So they're missing a T. The failure to spell the name correctly caused a problem. Danny, what was the problem that this typo resulted in?
Because his name was misspelled when he sold the property, the lien was not identified.
Yes. Okay, that's exactly right. When you want to buy a property, you want to make sure that the title's free and clear, right? You don't want to buy a property with a judgment against it. Why? Because someday down the road, people can now come put a lien on your property and maybe take it from you if you don't pay it, right? If you buy a piece of property with a lien on it, you're stuck with that lien. It doesn't go to the buyer, it stays with the property. So here, because of the failure to record it, someone bought a piece of property with a judgment on it. Now, the case is actually kind of funky, right? Who's actually litigating this case? Who's the party in interest? It's the lawyer. Right? The lawyer is actually the party in interest. So here's what happened. The lawyer screwed up, and he got probably sued for malpractice. So the lawyer basically paid the client whatever he was due. And now the lawyer is fighting to get his own money back. Right? So this is a weird case where the lawyer, the guy who screwed up, is also the guy suing, who's also the party in interest. He's like, this one guy does everything. Keep in mind, when you're lawyers, if you screw up, you have to pay. Right? If you make a mistake, you pay. Right? You make a typo on a deed, on a document, you don't spell the guy's name right, you pay. You submit a brief 1 minute late, the deadline's midnight, you put it 12:01, you blew the statute of limitation. Right? If you show up for court 1 minute late, the court can enter a default judgment against you. People always get annoyed when I yell at people for coming in late. You know, you're going to be lawyers. If you come in late to court, you lose. You lose your case for your client. You're screwed. Right? A minute late is late. I think even with your legal writing professors, if you put your assignment late, you're late. And that might sound awful and unfair. It's not. It's exactly the world you're coming into. So here, there was a typo. They misspelled the guy's name. Is that Danny?
Yes.
What was the argument that the lawyer advanced to try and salvage his case?
So he argued that even though the lien judgment wasn't shown from like the title report when the sale occurred, that new buyer did have constructive notice through idem sonans.
Idem sonans. Yeah. What is that doctrine?
That basically when a person's name has been inaccurately written, the identity of such person will be presumed from similarity of sounds.
Yeah.
So,
yeah. This is a doctrine that basically says, you know, when you have a commonly misspelled word or a word that can be spelled different ways, you have to search for all the variants. So Elliot with 2 T's, Elliot with 1 T, Elliot with 1 L maybe, right? There are different ways of spelling the name Elliot. Or think of, you know, nicknames, William and Bill, right? Or Tom and Thomas, right? Or, you know, maybe Margaret and Marge, right? Variants of names that are commonly shortened or abbreviated. John and Jack. Think of anyone you want.
Emily, is the court comfortable adopting this idem sonans doctrine?
not for property law.
Okay, tell me why.
They said it's inapplicable when the written name is material, and that having to search for different spellings in a title search, it would put an undue burden on the transfer of property.
Very good. Thank you, Emily. That's right. The court here does not adopt. The court here does not adopt the idem sonans doctrine because it creates a lot of work, right? However much work it is to search for Elliot with 2 L's, you have to double it, Elliot with 3 L's, or Elliot with 2 T's, whatever it is, right? You have to do the same search 2 or 3 times. That's very time consuming. And the court doesn't want to impose additional burden on title searchers. Also, I think they're not too keen on rewarding the lawyer here who screwed up, right? This was his mistake. He screwed up. We're not going to change the entire doctrine to reward him. So here, the misspelled deed did not provide constructive notice, and therefore he could not prevail. Okay. Questions on the Orr versus Byers? I like to say the buyer was actually named Buyer. You ever notice that? The buyer was actually the buyer named Buyer. Anyway, you're welcome. Okay. All right. Any questions on that? All right. I want to turn now to the recording acts. And let me make a few points before I get into 3 different kinds. Right? Again, between A and B, between the grantor and the grantee, you don't need to record. Right? It doesn't matter if you record. It's a binding transaction. The recording acts only make a difference when you bring in a third party. That's when these come into play. Right? And when you have a third party coming into the picture, it matters if you record. And it matters who records first. When I say, do you receive protection by the recording statute? What that means is even if you were not the first buyer, you might still prevail because of the recording statute. The recording statute answers a question: who has the stronger claim to the property, right? It's not who owns it. It's not just a simple binary question. It's you have different competing claims. The recording statute sort of tips the scale and says, aha, he has a stronger claim because he recorded first. Even though he wasn't the first buyer, he recorded first. Again, the recording statutes tip the scale over whose claim is stronger. And so you'll see on my exam questions, I always say something like, who has the strongest claim to Blackacre? I don't ask you who owns Blackacre. That's not a fair question. And the recording statutes will let you decide whose claim is stronger, A or B. Everyone with me? Everyone understand? Yeah? Okay, good. All right, there are 3 kinds of recording statutes, and you'll need to know all 3. Texas is the middle one, notice, but you need to know 3 of them, because I'll test you on it, and they come up every now and then. Kaylee, please talk about the first one, the race statute, R-A-C-E.
So a race statute is essentially a race to record.
It's a race to the courthouse, exactly, yeah.
So whoever is the first to record has the strongest claim.
Good.
Actual knowledge or race statutes is irrelevant.
Okay, very good. The race statute is the easiest one to apply. The easiest one to apply. Whoever records first wins. Right? Whoever records first prevails. You race to the records office. And so, for example, is that Shannon? I'm sorry, Sharissa. I'm sorry, Sharissa. I saw the SH. And I thought, Sharissa, you want to read for me this example number 2, please, on page 682? Example 2 on 683. I'm sorry.
Example 2. Owner Blackacre conveys Blackacre to A, who does not record B.
Uh-huh.
Subsequently conveys Blackacre to B for valuable consideration.
Okay, let me pause you for a second. This is going to be your standard question, right? O's a fraud. O's a crook. O sells Blackacre to A, turns around and sells it to B. So then the question becomes, who has the stronger claim between the 2 of them? Right? Who has the stronger claim between the 2 of them? Okay, keep going, Sharissa.
B actually knows of B to A.
Ah, so now we got a problem, right? B did something that's not so nice. What did B do?
They knew that
Why would B go ahead and buy Blackacre when he knows A already bought it?
If they're under the race statute, they just have to be the first one.
So they're both crooks, right? O's a crook and B's a crook. And then keep reading. Just finish the question, Sharissa. Keep reading.
B records the deed from O to B.
Okay, B records first. Now, Sharissa, even though B is a jerk and he's acting in bad faith, who prevails here? Why?
Because this isn't the race statute.
Exactly. In this jurisdiction, right? In this jurisdiction, B prevails. Now, here he had actual knowledge of A's transaction. It doesn't actually matter. In a race jurisdiction, whoever whoever records it first prevails. Now, Shannon, why would any jurisdiction adopt this rule? I mean, this is a pretty strict rule, isn't it?
It keeps it limits the inquiry to matters that are off the record.
It's easy to apply. There's no doubt. You have a dated deed, that's it. Now, what's the downside to this one, Shannon? I mean, obvious. Why is this one not very popular, you can imagine?
You reward the people who kind of do that.
Yeah, it's not fair, right? My least favorite word is in the English language, right? It's not fair. You're rewarding bad actors. So even though B knew about the transaction, he gets rewarded. This rule exists only in 2 states, Louisiana and North Carolina. So I mean, it doesn't exist a lot, but you'll see it. Yeah, Javier.
Would A be able to sue O for fraud?
Yes, but that doesn't give him Blackacre,
But
right?
But O didn't fraud A though. He frauded A at that point.
Oh, well, I think, okay, so at the time O sold to A, there was no fraud. But I think the act of O subsequently selling to B could be an act of fraud as well because it created a title problem. In other words, the reason why B has this deed was because of O's misdeed, if you will. So I think the subsequent act, could give rise to a fraud action.
For A.
Yeah, but I will never ask you about fraud in this class. It's actually not relevant. That's more of a tort contract type deal. All I want to know is who has a stronger claim to Blackacre, right? And between the two of them in this jurisdiction, B has a stronger claim to Blackacre by virtue of the recording statute. Make sense? All right, any question on the race statute? Okay, you'll see it every now and then, but they do exist in at least 2 states. Okay. All right, let's go on to the next one. The next one is fairly common. Indeed, Texas is one of these. What's called the Notice Statute. Jessica, you want to tell me, please, what's the Notice Statute?
So basically, if a subsequent proceeding that there was some sort of purchase on deed, then it wouldn't give him.
It wouldn't make them
Okay. Okay, so let's start like this, right? The difference between, or one of the differences between a notice and race is it doesn't reward bad faith. In the case we did a minute ago that Shannon and Sharissa talked about, B knew about A's transaction, and that was fine, right? The notice statute doesn't work in that fashion. If B knew about A's transaction, B cannot prevail. Right? Again, if B knew about A's transaction, B cannot prevail. So consider this example. Marie, you want to read example number 3 for us, please?
Yes. O, owner of Blackacre, conveys Blackacre to A, who does not record the deed.
Okay, so let me pause you right there. O to A, but A does not record. Okay, at that point, right, Maria, who would be the record owner of Blackacre? If you went to the records office and you tried to figure out who owns Blackacre at that point. Okay, now B comes along and buys Blackacre, right? Maria, at that point, is there any way for O to know that is there any way for B to know that O was engaging in some double dealing? No, why not?
Because there's no record of it.
Yeah, very good. So B has no knowledge of A's deed. And so who prevails here, Maria?
A.
Okay, why does A prevail?
Because
No, I'm sorry. I said it wrong.
Okay.
Why does, that's wrong. Who prevails here?
In the full example? Or?
Well, we're doing example 3 right now.
Okay.
Where B has no knowledge. Who wins? Oh, you're right. I'm sorry. You said it wrong. You said it right. Yeah, B prevails, right?
Yes.
Why?
Because he didn't know of
Yes.
of O's.
Yeah. B prevails here. I'm sorry, I tripped you up. B prevails here because he had no notice. He was a subsequent purchaser who purchased it without notice. Maria, does it matter that B never recorded? Is that relevant? Okay. In a notice jurisdiction, you don't need to record to prevail. B wins here even though B never recorded. Now, go to Andrea. Why are we recording B? Why don't we just give it to A? Right? Why do we even like give any credence to the subsequent transaction? Why shouldn't A prevail here? Right? Why do we give it to B? Neither of them recorded. Why do we want to reward B? Why?
Because they're being more responsible for their purchase.
But neither of them recorded. They were both irresponsible. Why do we reward B, Andrea? Why do we reward the subsequent purchaser?
They're innocent. I mean, they're not.
But so give it to A instead. Well, Andrea, let me ask you the question like this. What happens, you think, when B buys a land? What will B usually do? What do you usually do after you close on property? What do you usually do to the land?
I don't know.
Oh, in theory, right? You just bought a piece of property. What are you going to do to it? You go there. And if B goes there and it's empty, he starts building a house, whatever, right? Is A there at that point? Okay, now tell me what I'm getting at.
Okay. It's kind of like adverse possession. You're actually using the land. You're more likely to do it.
Right. Okay, so let's put it this way. If I want to buy Blackacre, I'm going to go there and check it out. If I go there and see A is living there, I'm going to say, what's going on, right? I'm not going to buy it. But on the flip side, if I go there and it looks empty, okay, I'm going to buy Blackacre. Then A shows up at some point in the future. The law protects the subsequent buyer, right? Because the subsequent buyer is there. He's on the land, and he's there innocently, right? More likely than not, if A was still there, the transaction would have never gone down, right? This transaction only happened because Blackacre was vacant. It was empty. If Blackacre had a tenant on it, you wouldn't buy it. Now, there might be cases where you buy it sight unseen. Okay, maybe whatever, right? But in the usual case, if B is there, if A is there, the transaction doesn't happen. All right, so again, the key factor of the notice statute is the subsequent buyer is protected regardless of whether he records. It doesn't matter if he records. Okay. Yes, Tyler?
So the verbiage, the way that it's phrased implies that B's protected because he provided valuable consideration and perhaps A did not.
Yeah.
Is that correct or incorrect?
You know, I don't know why the book always says valuable consideration for B but not for A. I know the reason why, but it's not terribly important. You have to be a subsequent bona fide purchase for value. Remember that phrase from contracts?
Yes.
It's possible that A was given as a gift, right? The recording statute only protects those who buy, not who receive gifts. That's the best I can come up with. I don't actually know why the book is obsessed with that, but that's usually how I think of it. But you have to be, remember BFP, subsequent bona fide purchaser? That's how I usually think of it. The book makes lots of judgments. They don't explain why they make them, and I have to sort of make my own theories. Maybe I'm right. I don't know. All right. Now, Laura, let me ask you a question, please. What are the downsides to the notice statute as opposed to the race statute? What are some of the problems with the notice statute? What's like one of the difficulties with this approach? Well, we said that the race statute's really simple, right? Why is race statute simple?
Oh, because it's always on record.
Okay. What makes this one not so simple?
It's not always on record.
Right. Laura, how do you show if a person had notice or not? What do you have to look at?
If they looked at the record, well, I don't know how to prove somebody looked.
Yes. How do you prove a negative, right? Exactly right. How do you prove a person lacked notice? It goes to their state of mind, right? You have to consider evidence. You know, maybe someone told them, maybe they heard a rumor, right? Maybe there's like surveillance footage of them going to the records office. You know, there are different things you can look at. But the notice statute has complexities because it requires evidence outside of the record, right? Now, the plus side is it's fair, right? It actually rewards the innocent purchaser. So there are plus sides and downsides. Okay, and I think I have the Texas statute somewhere here. Okay, section B. Okay. Right. Oh, here we go. Subparagraph 2. Okay. You have to have actual notice, right? Okay. All right. Let's go into the last one. Example number 4. The hardest one for students, it always gives students trouble every single year, is the race notice statute. The race notice statute. And as its name suggests, the race notice statute is sort of like a hybrid, where it merges features of both the race and the notice statute, sort of just gloms them together. Is that Hannah? Hannah, what's the race notice statute? How does it work?
So a subsequent purchaser can become against a prior unrecorded instrument only if the subsequent purchaser doesn't have notice of the prior instrument.
Or
Records before the prior instrument is recorded.
Okay, actually it's and, it's not or, but it's and. Yeah, thank you, and. Okay, very good. I said or, I'm sorry, I screwed you up, it's and. The race notice statute requires a couple things. Okay? The subsequent purchaser must not have notice. That's the notice factor. Test number 2, the Texas one. And the subsequent purchaser must record first. That's the race element, right? So it combines both. You have to record first, and you cannot have notice. You have to record first, and you cannot have notice. Everyone understand that? Kyle, you want to read example number 4 for me? It's on the next page.
O owner of Blackacre conveys Blackacre to A, who does not record B. O subsequently conveys Blackacre to B, who does not know of A's deed. Then A records. Then B records. A prevails over B because even though B had no notice of A's deed, B did not record before A did.
Okay, let's walk through this one step at a time. This one's a little bit trickier, right? O owns Blackacre, sells it to A, who does not record. Same as usual. O conveys Blackacre to B, who does not know. Okay? Now, Kyle, in a notice jurisdiction, if we just stop there, who prevails? We just stop at that sentence.
A would prevail because B didn't know.
No. Read it one more time. In a notice jurisdiction, O conveys to A, then O conveys to B. B does not have knowledge. Who prevails in a notice jurisdiction? What's the rule in a notice jurisdiction, Kyle? Who prevails?
If he knew about the deed, if A knew about the deed, or sorry, if B knew about the deed, then he can't prevail.
Did B know about the deed here?
No, he didn't.
So who would prevail in the notice jurisdiction? No. Why do you keep saying A? Who prevails in notice jurisdiction? The first buyer or the subsequent buyer?
The first one, right?
No. Andrew. Who prevails in notice jurisdiction? So who's A or B? B. It's not the first buyer, it's the second buyer, right? A was the first buyer, B was the second buyer. In a notice jurisdiction, the subsequent buyer prevails. So Andrew, again, I think you said it already, but in this fact pattern, who would prevail in a notice jurisdiction? B would prevail, okay. But we're not in a notice jurisdiction, right? We're in a race notice jurisdiction. So Andrew, what's the additional factor you need to prevail in a race notice jurisdiction?
You also have to record before.
Ah. So for B to win, what would have to happen?
They would have to have they would have to have
Lack of?
They would have to have no knowledge.
Good. And
they would have to record before A.
okay. Is that what happens here?
No.
What happens here?
A records before B. So A prevails.
A prevails, exactly. Even though B was a subsequent bona fide purchaser without notice, he failed to record first. Again, B failed to record first. As a result, because B failed to record first, the statute does not protect him. The statute does not protect him. Therefore, we're stuck with who's recording first, which is A. So A wins. So here, buyer number 1 prevails in a race notice jurisdiction. But the exact same facts in Texas would give it to B. So California is race notice. In California, A wins here. In Texas, B wins. The exact same fact pattern turns out differently based on the additional requirement of recording first. That's why the race notice always gives people difficulty. It's merging the race and the notice. And that's why it's called race notice, but it merges them two together. Okay. Questions on that? Yes, Akili.
Is there a reason somebody would not record? Is it
Lazy?
Yeah, 'cause I imagine it's
Takes
not
time,
that
effort.
expensive.
No, it's not expensive. It just takes time. You have to go to an office. You have to wait in line. I mean, when I first moved to Houston, I had to record my car or something, and it took me like 2 or 3 hours at the office. It was a pain in the neck.
Yeah.
I mean, it wasn't like difficult, but just I had to wait in line for a few hours, and you have to go to this office. You have to pay fees. People just forget. They don't do it. All right. If these examples don't make sense, go back on your own time and do examples 2, 3, and 4. Read them carefully and understand why, with this fact pattern, in Texas it's B and in California A wins. You have to get at least that much. If you get that much, I think you're in good shape. Okay. All right, let's try 685. There's a problem, problem number 1. Okay. All right, who's next? Is that Grace? Grace, you want to do problem number 1, please?
O conveys black acre to A and does not report. O subsequently dies, leaving H as her heir. H then conveys black acre to B, who reports. B purchases for a valuable consideration and without notice of the deed from O to A, who prevails.
Okay, what do you think happens here?
In which jurisdiction?
I don't think it matters.
Okay. B.
Okay, why?
He didn't have notice of the deed from O to A, and it was conveyed to him.
Yeah, I think that's right. And the next sentence is B prevails. So that's right. And it says, if H does not inherit Blackacre from O, how can he convey it? Okay. Let's walk through this one step at a time, right? O conveys Blackacre to A, who doesn't record. O then dies, leaving H as her heir. H conveys Blackacre to B. Now, Grace, at that point, did H actually own Blackacre?
Not technically, but there was.
Oh, no. I don't not technically mean that. I know what you're getting at, but just did H own it? Did O have any power to convey in her will Blackacre?
No.
No. When a person dies, the property in their estate is only what they have. If O had already conveyed Blackacre, Blackacre is no longer in her estate, therefore it can't be conveyed. Everyone get that? So H had no claim to it, but we still protect the subsequent bona fide purchaser for value. Right? We still protect B because B bought in good faith. Right? So unfortunately, A is out of luck. Okay, let's try the next paragraph, problem 2. Who's next? I can't see the tag. Morgan, you want to just do number 2, please?
O conveys right acre to A who does not report. O subsequently conveys to B who purchases in good faith and for a valuable consideration but does not report. A then records and conveys to C. C purchases in good faith and for a valuable consideration. B records, C records, who prevails under a notice statute, and then a race notice.
Okay, so let's take it one step at a time, all right? Let's start with a notice statute, right? We have a situation where O conveys to A who does not record. O conveys to B, also doesn't record. Then O conveys to C, who purchases in good faith. Now at this point, Morgan, is there any way for C to know about the previous transactions?
No.
Okay, well, O conveys to A, who does not record. O conveys to B, who does not record. But then A records and conveys to C. Is there any way for C to know about B?
No, because B didn't report.
Okay, that's important, right? When C buys Blackacre, there's no record of the O to B transaction. It doesn't exist. In fact, A probably doesn't even know about this transaction. So A is in good faith, I think B is in good faith, and C is in good faith. Then we learn that B records and C records. So Morgan, who prevails here under a notice statute?
C.
Why does C prevail?
Because he didn't know that was previously given to B.
Okay. Good. Let's walk through this one step at a time, right? Okay. Who prevails, B or C? I think the answer is C. Okay? Why? Because C was a subsequent bona fide purchaser for value. She could not have known that B was in the chain. So B, unfortunately, is out of luck. Okay.
Even though B recorded before C,
In a notice jurisdiction. Yeah, a notice jurisdiction. Okay, let's try a race notice jurisdiction, right? And this one's a little trickier. Okay? Where is it? Okay. In a race notice jurisdiction, let's do one at a time. A would prevail over B. Okay? Why?
A recorded it first.
Okay, very good. In a race notice jurisdiction, A recorded first. Therefore, A prevails over B. And because A prevails over B, A can convey a good title to C. C wins here also. B is out of luck no matter what. One more time, let's say this one more time. Because A recorded first, he can then convey it to C. And the A to C transaction is valid. B is screwed. Everyone see that? It's a little tricky. But that one's a little bit of a wrinkle. All right. I'm going to skip the last case. I always regret assigning because this case always runs late. The upshot of the last case, Messersmith versus Smith, which is an awful name for a case, involves notaries and acknowledgments. What is this? Whenever you have any sort of official document, you need to have a public notary who witnesses your signature. It's called an acknowledgement. And the reason why you have that acknowledgement is to ensure that the person signing it is actually signing it. Here we had some very funny cases, funny facts, where they signed a deed, they ripped it up, and then they signed another one, but it's not clear if anyone witnessed the signing. And what the court says here is that the failure to witness to acknowledge the signing makes it inadequate, right? That's not sufficient to put people on notice. Yeah.
I have a question about this. So,
Oh, going back to question 2?
yes.
Okay, good.
So the race notice statute, you have to have without notice prior instrument. So say A found out that O conveyed to B, and then would that not allow?
I'm sorry, say it one more time. A found out.
A found out that O conveyed to B, and then that's why A subsequently went to record. Would that still be allowed because it's without notice?
Well, but keep in mind the sequencing, right? It's when you bought it was there notice, not if you gained notice at a later date. All right, so my summary for you today is think very carefully about the race, the notice, and the race notice statutes. And as you do these sorts of questions, think very carefully, very, very carefully, please, about who has stronger claims. And I encourage you to go step by step from O to A, who recorded, O to B, who recorded, O to C. At each juncture, figure out who's recording when, and only then can you answer these questions. These questions are not straightforward. Okay. Any questions on this? All right, no class on Tuesday. Happy Constitution Day. I will see you next Thursday.